Welcome to our LinkedIn Live. My name is Lee Morin, and I'm the principal attorney and founding member of Morin Legal, your small business and entertainment law firm located on the East Side Atlanta Beltline Trail in the Old Fourth Ward in Inman Park neighborhoods of Atlanta, Georgia. Today, we're talking about contracts. And when I actually thought about in what context could we communicate basic tenets about contracts, I realized we were still somewhat limited to really the nature of our practice, which is mostly transactional and involves transacting either some type of intellectual property rights, either based in copyright law or trademark law, or some type of personal rights. For example, one contract that's pretty popular right now are the name, image, and likeness contracts that we're seeing circulating in the college football sphere. So when I thought about what types of contracts in what context we're going to take this masterclass, is really in respect to transactions involving intellectual property or some type of personal rights. So with that in mind, let's proceed into the top 10 aspects of a basic transactional contract. We're going to start with number one, the key terms. Key terms to any contract include the identity of the parties to the contract, and that can be really important depending on how you want to be taxed for the income you receive in the contract and other things. The subject of the contract, of course, is important. The consideration to be paid in the contract, which can include compensation but doesn't have to. The term or the period during which the contract should apply, and the territory in which the contract applies. Keep in mind now that contracts are really guidelines to behavior, right? In which parties agree to a certain course of conduct of doing business. So once we get the key terms, now, mind you, if you verbally agree to the key terms, in the event that those key terms will eventually be put into writing, depending on the nature of the agreement, you may have a binding agreement just verbally on reaching those key terms. So certainly consult an attorney if you're not really sure if you've reached a binding agreement. Now, the second most popular number two in our list of top 10 aspects to a transactional contract are the rights paragraph. So there's a provision usually discussing the rights to be transacted. And as I said earlier, the rights might either be based in intellectual property law, in some aspect of copyright law or trademark law or trade secrets even, and or personal rights, including commercialization of the person's identity, including the name, the image, likeness, and so forth. Celebrity endorsements fall under this category. And other types of merchandising licensing agreements. So number three, once we get past the rights being transacted in the agreement, typically we will see something related to confidentiality. And the trigger that lets you know that you are reading a confidentiality provision is that it usually has to define what is confidential information. So typically doing business with another party, you might get access to information that might not otherwise be publicly available, but be necessary for performing the agreement. And the parties agree that sharing such information will be done under certain conditions. And those are certainly outlined usually in some provision related to confidentiality. And those provisions are in the chief agreement, typically. Another way of looking at those are NDAs, non-disclosure agreements. Usually you'll enter into something like this prior to entering into a longer form or even a short form agreement. But just giving you kind of the broad brushstrokes of the functionality and the purpose of these types of paragraphs and agreements are to maintain disclosures to a minimum and only certainly on a need to know basis in order to perform the agreement. So that's very common to see these in your contract. Number four on our list are reps, warranties, and indemnities. And I like to tell my clients that they go together like carrots and peas because you really have them, they function hand in hand. Reps and warranties are things like representations reps is short for representations, but essentially representations of fact, material representations that you make in order to enter into an agreement that other persons are depending upon, warranties or promises of certain behavior that you'll perform to a certain level of care. And certainly indemnities are there in the event you break any of those representations or warranties, break any of those promises, misrepresent some aspect of the fact, and that entitles the person to be defended in that event. So reps, warranties, and indemnities have to go hand in hand because they function together. And you'll see these usually in that order in an agreement, usually mutually by both parties, although depending on the type of agreement, there might be more on one side than the other. Again, consulting a lawyer on this is essential if you're going to understand what you're actually agreeing to. Number 5 on our list are remedies. So what happens if somebody doesn't perform and suddenly they're in what we call breach? Well, a notice and cure provision is extremely helpful for functional reasons because it keeps you out from having to go to court right away to enforce an agreement. It just essentially means you're letting the person know they're not performing up to what they agreed to, and they have maybe 2 weeks to cure the conduct. And certainly that is one tool in the toolbox that is great to exercise. Maybe it was an innocent breach, accidental for yeah, mispayment, misfiring of a check or something, something innocent. But needless to say, is one step before having to go into the next bit, which is considering the termination, right? Number 6 on our list is termination. Always tell clients never get into an agreement you cannot get out of. So look for the termination conditions and what are the effects of termination. Do you have to give back documents? Are the materials you create frozen in the process? What type of agreement really determines what the effect of termination is. But it's always good to see that you have a paragraph related to termination or otherwise an exit from the contract. You don't want to get into something you cannot get out of. Number 7 on our list is alternative dispute resolution. This is an inexpensive and effective way of resolving your disputes. Again, if the person doesn't cure their conduct, you go into the next bit, which I like to keep it low cost and start with basic negotiation on the side of either party through the representatives. And then if that doesn't work out, going into mediation and after that, arbitration. Litigation is, depending on where the forum is, can be expensive and time consuming. It usually is. And our firm certainly does not litigate disputes. We would have to send you out externally to a litigation and trial practice. So certainly alternative dispute resolution is great in trying to take baby steps toward that more expensive dispute resolution, but and they're very effective. Number 8 on our list is the choice of law in the forum. This is important if you are going to have to settle your problems under the contract. Some contracts say, listen, we know that you're in Georgia, but the choice of law in this contract is going to be California or New York. And guess what? That's where the forum will be. And so you're going to be traveling to that state and staying in that city if for any reason you have to go into a mediation or an arbitration in California, for example. So that's something just to be aware of when you're making those tiny selections is, if the worst should happen, what are the consequences and what are the costs involved, and just keeping some type of business reserves on hand for that. All right, number 9, boilerplate. Boilerplate is on every contract. We like to think of it as one giant paragraph. You see it very often where people just smash together a bunch of what seem like sentence fragments, but really they boil down to a science that probably only lawyers speak. But if I could simplify it, essentially it's a paragraph talking about how this is the entire agreement. There's no other agreements that apply. All of your intentions are reflected in this one single document. That's something we call a merger agreement. It also provides, if the parties want to amend or change their terms, a mechanism for them to do that. It provides if somebody waives their rights to enforcement or to something else that they're not agreeing to a future waiver. It says, listen, if terms are illegal or otherwise impossible to perform, we can sever them from the agreement and not destroy the contract. There's other sections in the boilerplate on headings and counterparts if you're signing two different originals in different areas. Now we have electronic signatures. So our number 10 is signatures because you can electronically sign documents in the transactional space and be able to, with the exception solely of affidavits which need to be notarized. Right. Again, still those must be done in front of a notary in person in writing. So, but otherwise, electronic signatures have served us well in the contract world for transactional agreements. And that concludes our very brief Contracts Masterclass numbers 1 through 10 of basic parts on any contract. I want to invite you guys to join us for our next LinkedIn Live on April 5th, where we're going to talk about these aspects of contracts within a more narrow context of independent contractor agreements. We're really going to focus on employment agreements in the month of April. I think it's probably an interesting topic since there's so many interesting ideas being tossed around right now in that space. And we're going to talk about independent contractor agreements first. So join us on that LinkedIn Live. And meanwhile, sign up for our newsletter. Go to our website and scroll on down and sign up for our newsletter where you will get follow-up videos, links to videos, and other stuff that you might have, passed over accidentally, may have passed you by. And that way you don't miss anything. Again, my name is Lee Morin. I'm the founding member of Morin Legal, your small business and entertainment law practice on the Beltline. It's been my pleasure talking to you today about contracts, and I hope you have an awesome rest of your week.